Hello, hi, Assalamualaikum. My name is Nur Atika binti Zarunaha. I am for the class NMCI 4E. So, for today, I would like to thank to our lecturer, Dr. Muhammad Shawani bin Muhammad Pirus, to give an opportunity to do these assignments. We are related with the case of law industrial court. Okay, today for the agenda, which is related with the Telekom Malaysia Berhad with Zulkifli bin Syarif, and then in these cases, we are related the statement of the case, explanation to the five alleged offences, and then the respondent have no merit based on inter alia, and lastly the issue for the determination of this court. Okay, the first is the introduction. Okay, the party of the cases are Telekom Malaysia Berhad TMB, the applicant Zulkifli bin Syarif, the first respondent, and the Mahkamah Perusahaan Malaysia in Malay or Industrial Court in English. The second respondent is the Industrial Court. Okay, the first respondent accepted the offer and he commenced employment with the applicant on the 1st August in 1996. On the 11th June 2010, the first responder was dismissed after the panel of the Domestic Inquiry I unanimously found him guilty of 4 out of 5 charges of misconduct. Okay, prior to his dismissal, the first respondent who has served the applicant in various capacity for 14 years since 1st August in 1996 was the Assistant General Manager, Sport Marketing, Group Marketing Division of his applicant. His last draw basic monthly salary was RM 13,501 The applicant was contributing 90% of the first respondent the last drawn basic monthly salary as the employer portion of the employees provided fund, which is the EPF. So the applicant further paid to the first respondent and fixed monthly car allowance for RM 400. Okay, the next is the field through the chambers of the Sunni Vijaya case. Okay, the first respondent reported to the Datuk Ramli Signara, which is the Datuk Ramli since the 1st May 2010. When Datuk Ramli retired, the respondent was transferred to the Marketing Division. And then on the 1st April 2008, the first responder was transferred to the Sport Event Management Division and he reported to the one Miss Boy Wong Fan, the general manager of that division. Okay, the first respondent have been victim since 1st May 2008. He was not promoted, but Miss Wong Fan, who is the more junior to him and who has no experience in doing event, as she was from the corporate communication division, was promoted and the first responder was required to report to her. Okay, thereafter, the Miss Wong Fan marginalized the first responder responsibility, certain distinction among his staff resulting in the first respondent is not being to be able to execute his job properly, as well as damage his reputation in the market. So the Miss Wong Fan did not follow the procedure in managing the performance appraisal. Miss Wong Fan and Puan Sheri Azra Ali give him unfair ratings. Okay, the next is the dismissal of the first respondent is without just cause or excuse based on the following reason. So the DI was invalid as the panel proceed with the DI on the 4th May 2010 without he present, even though he was medically unfit to the participate in the DI. Second, he was denied or he was not an or deprived of the opportunity to fully understand the charge against him, to be prepared and or present or present his case in the DI as an applicant, and or the panel has failed to provide and to ensure that he have been provided with inter alia the policy and the manual refer to his charge. Okay, the second is the third is the disciplinary action take against him, which culminate of his dismissal, was executed by the malafide and intent to the victim him motivated by ulterior motive and constituted unfair labor practice. Okay, and the last point of the dismissal is the since the charge in this applicant managed in 2008. The first respondent faced harassment and the victimization over the last 2.5 years prior to his dismissal. Okay, this is the continue for the dismissal. Okay, the next is the harassment and the victimization include the harassment and victimization by Miss Boy Wong Fan. So he have been started early, but and then the next is further or in the alternative, even the first responder was guilty misconduct, which is the category is denied. His conduct, if any, have been condoned by the applicant based on the second terms of the case in particular. Okay, the next slide is the statement in reply the applicant plead inter alia in these cases. Okay, the first is the principle of the law relied upon by the first respondent, that as long as an unplead issue is put to the opinion witness during cross examination and the same was not objected when evidence is on unplead issue was adduced during trial, this is not applicable to the specialized domain of industrial. Okay, the second statement is the in the statement of the case supposed to be the first respondent is did not plead the act of misconduct allegedly committed by him were minor act of misconduct and did not warrant his dismissal. Okay, the third statement is third statement of the case is the first responder only pleaded the defense of condemnation but delay, but the applicant has success in showing that there was not condemnation by delay as the applicant always discovered the first respondent act of the misconduct after Datuk Rambe had left the applicant employment. And then the fourth statement, which is the defenses of the condemnation in the first respondent act by misconduct by Datuk Rambe was not pleaded by the first respondent. Okay, this is the continue for the inter alia. Okay, this demo of the case, the first respondent did not plead that the four charges were defective as the date of the coming into the force the MPP was not selected in them. Okay, the next is there is no right law that of the IRA 1967 can be used to recuse the first responder case of defense that the industrial court cannot rely on the section of the IRA in 1967 to decide on the ground which was not advanced in the peace case. Okay. The next is the first respondent also did not state in his reply to the letter of the show case that the MPP was not enforced at the time his offence was alleged to him to have been committed by him. And then lastly, the applicant adduced evidence of an email which is provide that is the first responder was aware of the MPP and the MPP was enforced at the time in the commission of the serious misconduct in the four charge. Okay, so the next slide is the attentive and or strictly without prejudice to the company position or the cases. Okay, the firstly is in consequence of the charge of misconduct proven against the claimant, the company has no longer had any trust or confidence in the claimant. Okay, accordingly, it will not be conducive to industrial harmony nor will be in the accordance with equity and the good caution to make any order of restatement of the claimant to his former position as the assistant general manager in this company. Okay, the second is in the good caution, the claimant must be made to bear something responsibility for his proof misconduct in the circuit terms and in the view of the claimant contributing conduct. It is a fit and proper case to scale downward and upward for the bed wages. Okay, the third attentive is the claimant ought the disclose and post-dismissal earning to his horrible court and the sum of the ought to be taken into account to scale downward and upward of the wages, bad wages. Okay, the next is in any event, the horrible court has no jurisdiction to award punitive compensation. Okay, the next slide is the respondent dismissal was with the just cause and excuse. So in order to discharge its burden of proof, the applicant opened its case and it called 7 witnesses. So based on these cases, I pull all the witnesses. To be actually we know who is the right and who is the wrong. Okay, the first of the witnesses is the Encik Zam Arfi Ismail, which is the chairman of disciplinary appeal committee DAC, which is rejected. The first respondent appeal against his dismissal. Okay, second is Encik Muhammad Yunus bin Raqub, is the second member of the panel of the DI, which unanimously found the first respondent guilty of the four of 5 charged misconduct of the state in the notice of the DI. Okay, the next is the Encik Muhammad Khalis bin Abdul Rahim, the chairman of the disciplinary committee with the DAC, which is decide that his misconduct committed by the first respondent in uh, 4 of the 5 charges as he state the notice of DI warranted dismissal. Okay, the fourth witnesses is, as we know, is Mr. Boy Wei Fan is the general manager, strategy event manager, section strategy event management, integrated marketing of the applicant who to whom the first responder reported on the 1st April in 2008, and he had requests to GIC to conduct to the special intern audit into the master agreement. Okay, the next is the Puan Shari Azra binti Azli, is the Vice President Group Marketing, who become the immediate superior of the first respondent with the effect from the 1st July 2009. When the first responder was transferred to the position of the Assistant General Manager, Group Marketing, and he reported to it was reissued to the first respondent. The latter issue caused with the 5 allegations of misconduct. Okay, the next is the Puan Heliza binti Hashim, is the Assistant General Manager, Industrial Relation, Human Resources Management, the plaintiff, who was the Secretary of the DC, which is decide that the misconduct committed by the first responder warrant his dismissal. It also the secretary of the DAC, which is rejected, the first respondent appeal against his dismissal. Okay, the next slide is the applicant's substantive judicial review application has no merit and ought to be dismissed by this court based on the following reason. Okay, the first reason is the even though the matter raised by the applicant were not plead in the IC cases, the applicant witnesses were cross-examined on the unpleaded matters without any objection from the applicant. Okay, the next reason in the case, the Court of Appeal had that if an issue is not pleaded in the case before the industrial court but is the ventilated in the industrial court and again in the high court without objection for either party, then it can be considered by the industrial court and the high court. Okay, the next is the view to the contrary expressed by the law Hopbing GCE in the decision of the Court of Appeal in the Rajit Kaur cases. On this issue are merely Obiter Tika and his lordship view on his issue were employed against the decision of the Court Appeal in the cases. Okay, the next is the decision in the case was also wrong and clearly contrary of the law clarified by the court in the Rajit Kaur cases as the federal court in the Rajit Kaur cases merely held that on the industrial court. Okay, next is the issue for the determination of this cause. Okay, on these cases, whether the industrial court committed an error of the law and of or fact when discredited the principle of law on pleading, which was clearly laid down by the federal court in Rajit Kaur cases, and it doing so consider unplead matters. And then the second is whether the industrial court committed an error of the law and of fact when it did not consider relevant matters, thereby rendering the award an irrational award. And then the second, the issue of this court is whether the industrial court committed an error of law and of fact when it did not perform its full function as laid down by the federal court in the Dreamland cases, Woon Yit Hock case, and the Mylan Out case to the IC cases. And then the next of the issue of this case is whether the industrial court committed an error of the law and or the fact when it decided that punishment of dismissal imposed that the first responder was too harsh as is too harsh or excessive, as the misconduct committed by the first respondent only was the minor misconduct. Okay, in the summary of the cases, in the instant case, I also found the industrial court finding that the first respondent have been able to find equivalent or the better employment and had not been offered permanent employment due to his dismissal by the applicant are perceived and diametrically contrary to the evidence on the record. Therefore, the industrial court failed to keep in mind the objective of industrial adjudication and the spirit of the fairness and the justice when it ordered the first respondent to be reinstated in the applicant, notwithstanding that is the first respondent had been away from the applicant about 6 long years and the first respondent had secured alternative employment. So thank you for me. I hope that all is good. Bye bye.